going to read this to you because it relates to everything I'm going through. The Constitution for the United States, 1789. This is Chapter 2, Title and Preamble. Title: The Constitution is for, not of. The word of expresses possession, in this case, a possession of the United States. Therefore, its creation to do with as it pleases. It denotes ownership, whereas the word for denotes something intended for someone else. In this case, a contract of the people intended for the United States. The Constitution for the United States of America contains 7 articles. Each article is a binding contract in the form of a statute representing the will of the people. In plain English, not legalese. Ordained and established by the people as the law of the land. Each article is restricted by the Bill of Rights, and all exercise powers are to contribute to accomplishing at least one of the 6 purposes of government defined in the preamble. I'm currently getting hit in the left eye with a direct energy weapon. Our founding fathers created a more perfect union, not an entity, which they referred to as a federal city for the United States of America. The Constitution called it a district, which is a region marked off for administrative purposes, for the seat of government, a government made up of representatives of each state, not a state unto itself. We, the people, are above the Constitution, for we created it to bind down our elected and appointed servants with the chains of the Constitution. Today, unfortunately, America has lost her way, and only the people can put her back on track through education, applying, guarding, and construing the law of the land. We must conquer our ignorance and brave independence. Only then might we restore liberty and become the land of the free once more. Here are some quotes. This is a Thomas Jefferson. At the Kentucky Resolutions in 1798, he said, "Put not your faith in men, but bind them down with the chains of the Constitution." Contracts and trusts in our world are everything. And that's what nobody has instilled in us, because I guess our parents just didn't know that. Contracts are everything. Everything we do during the day, when it involves really anything, we are contracting, whether conscious or unconsciously. We're always contracting. You go out and you buy, a piece of fruit from the store. You're contracting. Another quote from Thomas Jefferson in 1791, he said, "I would rather be exposed to the inconveniences attending too much liberty than to those attending too small a degree of it." He also said, "Enlighten the people generally, and tyranny and oppressions of body and mind will vanish like evil spirits at the dawn of day." Wow, that's so fitting. That's so fitting to my life. Tyranny and oppression of body and mind will vanish like evil spirits at the dawn of the day. Oh, if you could only understand. In the preamble, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Purpose of the federal government is defined in the preamble. Preamble, quote, a clause at the beginning of a constitution or statute explanatory of the reasons for its enactment and the objects sought to be accomplished, end of quote. Townsend v. State, 147, Indiana, 624, 47, N.E. 1937 L.R.A. 294, 62, Am. State Republic 477. Also Finner v. Luzerne County 167, Pennsylvania 632, 31A 862. We the people, by declaration, established government by consent, and it is in the Constitution that we gave and limited that consent to our servants. By establishing and ordaining the Constitution for the United States of America, we, the people, formed a more perfect union. Any servant that varies from our laws and seizes authority that we, the people, did not authorize, wars against the Constitution and therefore the people. They are in bad behavior, and it is the duty of we, the people, to remove them from office and try them for treason as provided for in the Constitution. Quote, any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. End of quote. That's Cooper v. Aaron, 358 U.S. 1, 78 S. Let's say Southern Connecticut, 1401, 1958. We the people proposed government to serve we the people by vesting legislative powers in 2 houses of Congress, executive power in a president, and judicial power in 1 Supreme Court, whose only resolve is to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty within their vested jurisdictions. The blessings of liberty. Quote, federal jurisdiction cannot be assumed, but must be clearly shown. That's Brooks v. Yawkey, 200 F. 2D 633. And to quote, the law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. End of quote. That's Hagens v. Levine, 415 U.S. 528. Under legislative powers, I'm reading here in Section 6. And under Section 6, number 2, it says, no senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emulates whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. So under notes with this, it says, provided that congressmen shall hold only one office at a time, that they may not take money for a vote, may not increase their own compensation, and that lobbying constitutes bribery. The whole system right now is bribery, is it not? Is it all about lobbying right now? I mean, especially you have AIPAC right in the forefront of that lobbying, do you not? Here are 18 enumerated powers, and this is of the legislative branch. These 3 sections are the most important to understand because they define and restrict legislative powers of Congress. Because of our ignorance with regard to these, we have out of control legislatures destroying our liberties. Therefore, it is here that we must draw the line in the sand, binding government with the chains of the Constitution. Article 1, Section 8 enumerated 18 powers vested in Congress. Article 1, Section 9 enumerated 8 prohibitions of Congress. Article 1, Section 10 enumerated 3 prohibitions of the states. This is where the rubber meets the road. This is where American tyrants empower themselves after lulling us to sleep. Any legislation outside the enumerated powers in Section 8 is null and void. Any legislation in violation of our unalienable rights is null and void. Any legislation prohibited by Section 9 or prohibited by the states is null and void. The United States Supreme Court has made these conclusions clear in the following cases. It is time to wake up. All laws, rules, and practices which are repugnant to the Constitution are null and void. That is from Marbury v. Madison, 5th U.S. 137, 180. Quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. End of quote. That's Miranda v. Arizona, 384 U.S. 436, 491. Quote, that statutes which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. End of quote. That's Hoke v. Henderson, 15, North Carolina, 15, 25 a.m., December 677. Quote, the general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since its unconstitutionality dates from the enactment and not merely from the date of the decision so bringing it. An unconstitutional law in legal contemplation is as inoperative as if it never had been passed. Such a statute leaves a question that it purports to settle just as it would be had the statute never been enacted. No repeal of an enactment is necessary since an unconstitutional law is void. The general principles follow that it imposes no duty, converses no rights, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. End of quote. That's from 16 Am. Jur. 2D, SEC. 256. That's America jurisdiction. Section 8. 1. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, I think it's supposed to be imports, and excises to pay the debts and provide for the common defense and general welfare of the United States. But all duties, it actually says imposts and excises shall be uniform throughout the United States. A note on this. Article 1, Section 8 consists of 18 clauses defining the 18 powers of Congress. The note for 1 that I just read was vested Congress with power to tax in order to provide for 3 things only. 1, to pay debts. 2, to provide common defense. And 3, to provide for general welfare. Section 8, number 2. To borrow money on the credit of the United States. The note for that is, provided the solution used by President Lincoln, i.e. to borrow from the people by way of greenbacks and bonds. Section 8, number 3. To regulate commerce with foreign nations and among the several states and with the Indian tribes. A note for number 3 is provided Congress power to regulate commerce, to enact all appropriate legislation for its protection or advancement, to adopt measures to promote its growth and ensure its safety, to foster, protect, control, and restrain commerce. Virginian Rye Company versus System Federation number 40. Railway Employees Department of American Federation of Labor, CCA, Virginia 84, Federal 2D 641, 650. Also, power to prescribe rules by which commerce is to be governed and embraces prohibitory regulations. That's U.S. versus Darby, U.S. Georgia 61, South Connecticut 451, 456, 312, U.S. 100, 657, 85, L. ed. 609, 132, A. L. R. 1430. Section 8, number 4. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. A note on number 4 is provided the naturalization law of the United States, that an alien be required to renounce all allegiance to any foreign prince, potentate, or sovereign whatsoever, that becoming a U.S. citizen meant you became a citizen to all states. Why would you need to declare yourself of any state then? Section 8, number 5. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. The note for number 5. Empower Congress to manage our economy. The Federal Reserve is a foreign bank owned by foreigners who control our money, which is backed by thin air, charge income tax for its profit, and raid and arrest we the people, throwing us into debtor's prison for not paying. This can only be described as monopoly, RICO, and extortion. In the 1930s, Congress and the President robbed the peoples of their gold and made it illegal to own gold. In 1981, President Ronald Reagan looked to reintroduce the gold standard and appointed a group called the Gold Commission. They found that the U.S. Treasury owned no gold at all, and that all the gold remaining in Fort Knox is held as collateral by the Federal Reserve against the national debt. In 2009, the government arrested anyone exchanging gold coins minted with Ron Paul's image. Wow. Section 8, number 6, to provide for the punishment of counterfeiting the securities and current coin of the United States. A note for number 6, provided Congress authority for counterfeiting laws. Wow. Provided Congress authority for counterfeiting laws. Number 7 in Section 8, to establish post offices and post roads. A note for number 7, provided Congress authority over post offices and post roads. The Postal Reorganization Act, Public Law 91-375, passed on August 12, 1970, created the United States Postal Service, an independent agency, an oxymoron. Independent means to be free from external control and constraint, removed from government control, whereas agency, according to Webster's, is a unit of government. Number 8 of Section 8, to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. The note for that is authorize Congress to promote useful science and arts. Section 8, number 9, to constitute tribunals inferior to the Supreme Court, which authorized Congress to create Article 3 courts. Section 8, number 10, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. The note for that authorized Congress to provide law enforcement at sea. Section 8, number 11, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Number 11, authorize Congress to declare war, grant letters to provide products and services during wartime, and to retaliate against any enemy during wartime. Section 8, number 12, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. That authorized Congress to raise and support an army. Section 8, number 13, to provide and maintain a navy. Obviously, that authorized Congress to maintain a navy. Section 8, number 14, to make rules for the government and regulation of land and naval forces. That authorized Congress to regulate land and naval forces. Section 8, number 15, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. That authorized Congress to call militia to suppress insurrections and repel invasions. Did not authorize Congress to create Homeland Security. Section 8, number 16, to provide for organizing, arming, and disciplining the militia and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the principle prescribed by Congress. That authorized Congress to arm and discipline the militia and to provide armies within the countries. Found that within the counties. It's within the counties. Section 8, number 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Section 8, number 18, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That authorized Congress to make laws providing for the foregoing 17 powers. Another quote by Thomas Jefferson. The two enemies of the people are criminals and government. So let us tie the second down with the chains of the Constitution, so the second will not become the legalized version of the first. Thomas Jefferson also said, if the present Congress errs in too much talking, how can it be otherwise in a body to which the people send 150 lawyers, whose trade it is to question everything, yield nothing, and talk by the hour? That explains why nothing gets done in Washington, because many of them are lawyers. Section 9, number 1, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, that's 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. That allowed for slave trade between the states outlawed by the 13th Amendment. That was the 14th. Section 9, number 2. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Section 9, number 3. No bill of attainder or ex post facto law shall be passed. Bills of attainder, as they are technically called, are such special acts of the legislature as inflict capital punishments upon persons supposed to be guilty of high offenses such as treason and felony. Without any conviction in the ordinary course of judicial proceedings. If an act inflicts a milder degree of punishment than death, it is called a bill of pains and penalties, but both are included in the prohibition in the federal Constitution. Also, State v. Graves, 352 Missouri, 1102, 182 SW 2D 4654. That's so funny. It's the most narrow strip of grass I could show you. And how many times did he have to mow over that? For good measure, you know. Ex post facto law. A law passed after the occurrence of a fact or commission of an act which retrospectively changes the legal consequences or relations of such fact or deed. By Constitution, U.S. Article 1, subsection 10, the states are forbidden to pass any ex post facto law. Section 9, number 4. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. Number 4 is saying it prohibited income tax. No income tax. Congress cannot, by any definition it may adopt of income in this case, conclude the matter, since it cannot by legislation alter the Constitution from which alone it derives its power to legislate, and within whose limitations alone that power can be lawfully expressed. That's Eisner v. Macomber, 252 U.S. 189. The 16th Amendment does not justify the taxation of persons or things previously immune. It was intended only to remove all occasions for any apportionment of income taxes among the states. It does not authorize a tax on a salary. That's Evans v. Gore, 253 U.S. 245. Section 9, number 5. No tax or duty shall be laid on articles exported from any state. Number 5. Prohibited tax on articles exported from any state. This relieves export taxes between states on cigarettes and alcohol. Section 9, number 6. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obligated to enter, clear, or pay duties in another. That number 6, prohibited taxes between the states entering through ports. Section 9, number 7. No money shall be drawn from the Treasury but in consequence of appropriations made by law, and a regular statement and account of receipts and expenditures of all public money shall be published from time to time. Number 7, promoted poor accounting, misappropriation of funds, lost money is a crime. Do you hear that? Prohibited poor accounting, misappropriation of funds, lost money is a crime. That's happening now. They're doing those accounting procedures, you know. Section 9, number 8. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept any present emolument, office, or title of any kind whatsoever from any king, prince, or foreign state. That prohibited titles of nobility. Esquire, in English law, is a title of dignity next above gentleman and below knight. Also a title of office given to barristers at law, justices of the peace, and others. 1 BL. Commission, all at Blackstone Commission, 406. 3 Steph. Com. 15 note. Tomlins on the use of this term in American law, particularly as applied to justices of the peace and other inferior judicial officers. See Christian v. Ashley County, 24 Arkansas 151. Korn v. Vance, 15 Surge and R. Pennsylvania 37. Barrister is an attorney, an officer charged with representing and defending parties before the tribunal to which he is attached. That's from Black's 4th edition. Section 10, number 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law or law impairing the obligation of contracts, or grant any title of nobility. This prohibited treaties, alliances, confederations, coinage, credit, legal tender, bills of attainder, ex post facto laws, titles of nobility. Section 10, number 2. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. Section 10, number 3. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. So I think that pretty much tells us that our country has been at war for a long time, and that's why they fly the flag that they have right now. It's the war flag. And that's how they keep the military going, because you must stay at war to keep them going. Wowee. Wowee. Let me read, let's go back here. I want to go back to the note about the taxes. So, in section 2, number 3, representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3. Massachusetts 8, Rhode Island and Providence Plantation 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. But those numbers should be much larger now, considering that way more people are living in each state than. Section 1, number 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Article 2, Section 1 consists of 8 clauses. 1. Vested executive power in a President of the United States. Section 1, number 2. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. And that, of course, described an appointment of electors. Number 3, the electors shall meet in their respective states and vote by ballot for 2 persons, of whom 1 at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and of the House of Representatives, open all the certificates. And the votes shall then be counted. The person having the greatest number of votes shall be the president. If such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person has a majority, then from the 5 highest on the list, the said House shall in like manner choose the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum from this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. So number 3, describe the process by which the president and vice president are elected. Amendment 12 and Amendment 20, ratified on June 15, 1804 and January 23, 1933, respectively, amended Clause 3, changing primarily how the vice president was elected. In the original electoral process, the person receiving the second most votes was elected vice president. Without a majority of votes, the process was a little confusing, but there appeared to be two states. The 12th Amendment clarified that there were 2 elections, one for president, the other for vice president, which seemed logical. Today we use the Electoral College to choose our president, but in doing so, the choice is made for both the president and a vice president, whom the president chose as a running mate from the same political party as that of the president. There is no constitutional support for this. It is not lawful and needs to be corrected. Yes, that definitely is different than what we have going on. Interesting. Number 4, the Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the U.S. Number 4, just authorize Congress to determine the date of appointing electors and the day for their votes. All right, number 5, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. Here's a note about number 5. Describe the eligibility requirements of the president and vice president. Natural-born American citizen is a person born in America or abroad whose parents are both, at the time of his birth, American citizens domiciled in America. President Obama was the first president not natural-born because his father was not an American citizen. Native, a natural-born subject or citizen, a denizen by birth, one who owes his domicile or citizenship to the fact of his birth within the country referred to. The term may also include one born abroad if his parents were then citizens of the country and not permanently residing in foreign parts. That's U.S. v. Wong Kim Ark. 6. In case of the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until the disability be removed or a president shall be elected. Number 7, the president shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. So they literally, it sounds like they granted compensation for the president, but then doesn't that say that they can't be paid by anyone else? Number 8, before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. That is their oath of office. Where did that go? Section 2, number 1. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states. When called into the actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Article 2, Section 2 consists of 3 clauses. 1, appointed the President as Commander-in-Chief, and 2, empowered him to grant reprieves and pardons. Section 2, number 2. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. Number 3, the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. So number 3, empowered the President to fill all vacancies. 6, vested powers. Oh, I'm blessed with more devices in the ceiling. What a blessing! 6 vested powers. We, the people, vested the President with 6 powers. The 5 granted in Article 2, Section 2, and the power of veto granted in Article 1, Section 7. Additionally, the President can be very influential through the use of the bully pulpit, the White House itself as a powerful platform for which to speak. Nevertheless, that is the limit of the power that we, the people, have given our President. He does not have legislative powers. There is no such given power as executive orders. All such orders are unconstitutional and therefore null and void. Wow! Section 3, number 1. He shall from time to time give the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office when impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. All right. Let's take the test for that one. Article blank vested the executive power of the United States item 1. It would be Article 1. It would be Article 2. Whoa. All right. Article 3, Judicial Powers, Section 1, Number 1. The judicial power of the United States shall be vested in 1. Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. A note on this is Article 3, Section 1 consists of one clause. 1. Vested judicial power in 1 Supreme Court and federal district courts, referred to as Article 3 courts. Today, the United States is divided into 94 districts, each with a district court. The Constitution holds that judges may remain in office during good behavior, meaning as long as they uphold the law of the land. Section 2. Number 1. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies in which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. The notes on this section. Article 2, Section 2 consists of 3 clauses. 1. The judicial powers extends to all cases in law and equity. Chancery courts are unconstitutional and do not constitute due process as protected by Amendment 5. The processes of law and equity are guided by Article 6, Clause 2, right to be tried under the law of the land. Amendment 5, right of due process. Amendment 7, right to be heard under common law. Any court that denies these rights are unconstitutional. Any judge that makes such rulings in such a court is in bad behavior, wars against the Constitution, and is committing treason against the people. If such a judge does not yield to a writ of error, they should be indicted and arrested for treason. That is very important, because our court systems do not If you mention the Constitution, oh, they get furious, evidently, from some of the things I've heard. All right, so this is section 2, number 2. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So that granted judicial jurisdiction. Number 3, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. A note for number 3, provided that all crime cases be tried by jury. Judges are not authorized to make summary judgments. Doing so constitutes treason. Section 3, number 1. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Section 3, number 2. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeit, except during the life of the person attainted.